I'm sorry about that. There was a problem with the AV system, which is now resolved. Good morning, Mr. Kapadia.
Good morning.
Will you say the words of the affirmation after me? I solemnly, sincerely and truly
I solemnly, sincerely and truly
declare and affirm
that
I will tell the truth,
I will tell the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
Ms. Thompson.
Good morning.
Good morning.
What is your full name, please?
My full name is Dev Kapadia.
How old are you, Mr. Kapadia?
I am 58.
And what is your occupation?
I'm a Procurator Fiscal Deputy.
You were sent some questions by the inquiry team.
Yes.
What we call a Rule 8 request. And you responded to those questions in writing.
I did.
What we call a Rule 8 response, which is effectively your statement to the inquiry. To your left, Mr. Kapadia, there is a blue folder. And if you open that up, there should be a copy of your Rule 8 response within. It's got the inquiry reference number 218. And if we turn to the final page of that document, sir, I'm sorry, but there appears to be a difficulty with the live transcription. I'm advised that it has stopped. It's working. Sorry for the interruption. Do you see a copy of your Rule 8 response within the folder, Mr. Kapadia? If we turn to the very last page, we see that if we can scroll to the very bottom, please.
Yep.
It's dated the 21st of December of 2022.
Yes.
And although your signature has been redacted on the screen, I believe that the copy in the folder will have your signature on it.
Yes.
You have helpfully incorporated all of the questions that you were asked into this document, so it's a composite of both the questions you were asked and your responses. If we look at the penultimate paragraph, that's paragraph 45, it states, I believe the facts stated in this witness statement are true to the best of my recollection.
Yes.
And you go on to confirm your understanding that the statement may form part of the evidence before the inquiry and be published on the inquiry's website.
Yes.
Did you answer the questions you were asked truthfully?
Yes.
Did you do your best to give as full and accurate responses as you could within the confines of your recollection?
I did.
You can look at that at any time if you would find it helpful to do so. I'm going to take you to some of the paragraphs. If there are other paragraphs you would find it helpful to go to, please let me know when we'll bring them up on the screen. Let's begin with paragraph 1 of, I'll simply call this your statement by way of shorthand. The question you were asked was your position in the Crown Office and Procurator Fiscal Service on the 3rd of May 2015, how long you'd been in that position, your duties and responsibilities. And you explained that on the 3rd of May 2015 you held the position of Senior Procurator Fiscal Depute in COPFS based in the Dunfermline office. At that time you'd been in the role as a Senior Depute for 6 years, although you'd been in the service since January 2000
That's
as a
correct.
Procurator Fiscal Depute. So as at May of 2015 you had about 15 years experience in the service.
That's correct.
6 as a Senior Depute.
Yes.
If we can scroll down a little, please. You go on to explain what your role involved. My role as a Senior Court Depute was to make decisions on reports received from the police, otherwise known as marking cases, other reporting agencies, and then decide on appropriate action, to prepare and conduct criminal prosecutions in both summary and solemn level, to mentor and provide advice and support to colleagues when required, to deal with search warrant applications and other legal requests, and give advice and instruction to reporting agencies and other external organisations as appropriate. You go on to explain that you were also an on-call depute as you had the relevant experience. You dealt with on-call requests appropriately, giving advice and direction as necessary to the calling police officer. bearing in mind not to interfere with operational matters within the jurisdiction of the Police Service of Scotland.
That's correct.
So your responsibilities were wide-ranging. You've outlined some of the key responsibilities at that time, which included decision-making around whether to prosecute a case that was reported to you by the police or another agency,
Yes.
preparing and presenting cases in court, and dealing with applications for search warrants.
That's correct.
I'd like to ask you some questions about your role as an on-call depute specifically. Should we understand that the on-call depute system allows access to the Fiscal out with ordinary working hours?
That's correct.
So that would be evenings, possibly overnight, and also weekends.
Yes, it starts at 5 o'clock on Friday afternoon, carries over into the weekend until 9:15 in the morning, and then you resume your duties at 5:15 in the evening, and so on until 9 o'clock on Friday morning when the on-call period ends.
So is the on-call period Friday to Friday?
Yes,
A week at a time?
that's correct.
And is this some sort of rota system within the Fiscal Service?
It is, yes.
One of the questions you were asked was how often you had been on call, and you say elsewhere in your statement that you would be on call 6 or 8 times a year,
Yes.
that you'd been on the rota since 2003, and so you estimated that you'd perhaps been on call about 60 times in total.
It's a rough estimation, but yes, based on how often you'd be on call during the year. Sometimes it's less, sometimes it's more. Sometimes you have to step in at the last moment if somebody has to pull out, for example.
You explain in your statement that you deal with requests from police officers
That's correct.
out of hours. How would a police officer who needed to contact the on-call Fiscal get in touch with you?
The system now is that a police officer has to obtain the permission of an inspector before they're allowed to make that call, and the call comes in from force control. It depends on whether they've got your phone number or not, but for example, if I'm on call for Central and Fife, the call comes in from East Overview. They say we've got a police officer, and then they patch the officer through, and you then speak directly to the police officer. In Tayside, the police officers contact you directly.
What was the position in 2015?
Looking from my on-call sheet, there was a call from force control. So they would have called me to say we've got a police officer on the line, and then a couple of minutes later I got a call from the.
So that system was already in place
Yes.
back in 2015. What sorts of requests might you expect to get as an on-call depute?
The requests have changed, no longer deal with homicide calls. That's now dealt with specialist homicide deputes. But in general, it's usually about drugs, serious assaults where police are looking for clothing, weapons, sexual offences, for example, electronic equipment, phones, laptops. And that, I would say, encompasses the majority of phone calls.
Are
And drugs, sorry.
Sorry. Are these the sort of things that you might deal with during office hours as well?
Yes.
You said, you mentioned drugs. The police might want to seize drugs.
Yes.
What sort of call might you get in relation to drugs?
It's usually with large amount of drugs where police have got information that drugs might be on the move from, say, a safe house to, or somebody's carrying drugs, and it's in relation to the large supply of drugs, if I can put it that way. Another area is where there are dirty drugs. Somebody has died as a result of ingesting drugs, and the police might call you to say, we believe that this person died as a result of ingesting drugs, and there is a need to try and find the source of those drugs, to try and take them off the street, to prevent any further supply and anybody else being harmed by them.
And in either of these situations, what are the police asking you to do? What's the nature of the request that they're making of you?
They would be requiring a search warrant under the Misuse of Drugs Act, and they would be asking you to make an application to the on-call sheriff. My job would then be to prepare the search warrant, draft the search warrant, usually send it back to the police officer to check that the details are correct, particularly in relation to the premises, because it's quite important to get the address on the search warrant. There can be mistakes elsewhere which are not that important, but it is very important to make sure that the address to be searched is in fact correct. Thereafter, to contact the on-call sheriff to explain the situation, and then the on-call sheriff would then contact the police officer because the drugs warrant's required to be sworn on oath by the police, and then the sheriff will either grant or not grant the search warrant. It comes back to you, and you then give it to the police to then execute.
All right. So these calls you can receive during office hours too, but when these sorts of things happen out of hours, the police would contact the on-call Fiscal for assistance with the request for a warrant. If a sudden or unexpected death occurs out of hours, the sort of death that might require to be reported to the Fiscal, would that be brought to the attention of the on-call deputy?
It would depend on what the cause of the death was. When I was certainly dealing with deaths, you usually got, and they were almost always in relation to homicides, but I can't remember when that stopped. But I virtually got no calls about deaths unless it related to some adulterated drugs, if I can put it that way.
You mentioned earlier there being a homicide team that also provided an on-call service.
Yes.
Would they receive calls about sudden and unexpected deaths?
Yes.
All right. So we may hear evidence that Mr. Baio's death, which occurred on Sunday, the 3rd of May 2015, was notified to the on-call Fiscal, but that wasn't yourself, it was someone else.
It wasn't me.
All right, and is there a possible explanation for that there was a different Fiscal on-call for homicides and other reportable deaths? Before we move on from this particular response to a question asked of you, you say at the bottom part of what we can see on the screen that you dealt with on-call requests appropriately, giving advice and direction as necessary to the calling police officer, bearing in mind not to interfere with operational matters within the jurisdiction of the Police Service of Scotland. Yes. Can you help us to understand what you mean by operational matters and why you shouldn't interfere with them?
I don't have any direct control over the police. I cannot tell a police officer what to do and what not to do. If the police are in the course of an investigation, they have their own procedures to follow, and I would have very little influence over how they go about conducting their investigation. I can provide helpful hints, but the police are under no obligation to take my advice, and they would have their own procedures to follow. So that is what I would call operational matters.
So it's respecting the parameters of your role
Yes.
and also understanding the parameters of their role.
Absolutely. I mean, we have separate functions, and part of my function is to have an overview of what the police can or cannot do, and that is in relation to search warrants, where if I feel that there is insufficient information given to me, then I would not. I would say to the police that I'm not approving this particular warrant. I'm not going to take it to a sheriff.
And what would happen thereafter would be an operational matter.
How they then conduct the search, what methods they use, is entirely up to the police, and I would have no influence over that.
All right. Well, perhaps return to that later, but for present purposes, that would be an example of you not looking to trespass on the function of the police.
Yes.
Can we go to paragraph 22, please? You've already told us a little about the process that you follow when you receive an application for a warrant, in particular a drugs warrant.
Yes.
There's some further information in this paragraph, so I'd like to go through it with you and ask you a few questions. You begin by explaining that, generally speaking, the police will crave a warrant to secure evidence where the occupants of the property will not freely allow police access. The purpose of the search warrant might be to seize drugs, electronic equipment, stolen property, clothing, firearms, or other weapons. You mentioned there a situation where the occupants of the property will not freely allow the police access. Should we understand then that in a situation where the occupants are quite happy for the police to come in to carry out a search, there wouldn't be a need for the police to seek a warrant?
Generally speaking, it depends on who the occupants are, what control they have over the property, and whether they are freely allowing the police to enter the property. On occasion where I've got a call from the police to say that the occupants will have said that we can go in and look for whatever it is they're looking for, I would explain to the police officer that as long as the occupants were aware that they had the right to refuse, so they were making a free choice, then there would be no need for a warrant. But in the majority of instances, it's always safer to go in with a warrant than not.
You go on, the Procurator Fiscal's role is to assess the intelligence, its quality, and the necessity to use force to secure whatever evidence the police reasonably believe is likely to be in the property. Once it passes that threshold, the Procurator Fiscal will draft the search warrant and submit it to the Sheriff with the relevant details, and it will then be a matter for the Sheriff whether or not there is sufficient information or intelligence to grant a warrant. For search warrants which require to be sworn on oath or affirmed, mainly firearms and drugs, the deponing officer will have to address the Sheriff directly about the veracity of the intelligence. You explained there, Mr. Kapadia, that it would be your role to assess the intelligence and the quality of that intelligence. Yes. Can you help us to understand how you go about that task?
The police, when they receive intelligence, is graded according to where the information has come from and how reliable that information is, and they have a grading system which I'm sure the police can explain it better than I can. If it's just gossip, then that would be the lowest quality of intelligence. They would still record it, but it would not be intelligence that I would find satisfactory enough to proceed with approving a warrant to go to a sheriff.
So you carry out an assessment of the quality of the intelligence, looking at both the information itself and the source of
Yes.
the intelligence. And you explain in your written answer that you also consider the necessity to use force
Yes.
to secure the evidence that the police believe will be in the property. For the benefit of members of the public who are following your evidence, should we take it from that if a warrant is granted, it will authorise the police to use force?
Yes, it does.
And that would be to use force to enter the property?
Yes.
And any locked cupboards or safes within the property,
Yes.
and to seize anything of evidential value that was found
Yes.
within the terms of
That's correct.
the warrant. Sorry, could we scroll up a little bit, please? Thank you, perfect. The bottom paragraph on the screen, you explain about assessing the intelligence, its quality, and the necessity to use force. And you go on to say once it passes that threshold, the Fiscal will draft the search warrant. So should we understand then that you will assess the intelligence according to the grading system that you have described, and also you will take into account that if the warrant is ultimately granted,
Yes.
it is giving the police the power to use force to enter someone's home potentially and
That is
to
correct.
seize evidence. And that's a consideration that you weigh in the balance when deciding whether or not to present a warrant to a sheriff.
If there is enough evidence or enough intelligence for the police to reasonably suspect that there might be firearms or drugs within a property, then that would be enough for the warrant to be granted. How much force the police then use to enter that property will be dependent upon the circumstances. For example, somebody at the property might say, well, you don't have to use a battering ram to come in if you've got a warrant, I'll open the door for you. Others might barricade themselves in. Drug dealers or houses where drugs are stored generally have some sort of barricades behind them, and it will require quite an amount of force for the police to enter, which might give the occupants a little bit more time to dispose of the drugs if they're so inclined to do so.
You said in your response to the question I asked if the police have reasonable grounds to suspect. Is that the test? Is that the threshold that you refer to in your written response?
Yes.
So you're assessing intelligence
Yes.
according to the grading system with a view to reaching your own independent view, independent of the police, as to whether the intelligence is such that the officers have a reasonable ground to suspect that there's evidence within a particular property.
Yeah. Over the years, I find that the police's self-assessment of their intelligence is perhaps higher than an independent person might think.
So can the police be optimistic, shall we say,
Yes.
in their applications? But at the end of the day, what I understand from your evidence is that you, in applying this test, you have a gatekeeping function.
That is pretty much in a nutshell, yes.
So the police cannot approach a sheriff directly. They have to go via you as the gatekeeper.
Yes.
They will have made their own assessment as to whether the intelligence they have forms a reasonable ground
Yes.
to suspect that there's relevant evidence within a particular property. But you will carry out that assessment yourself, objectively, and if you agree with the police, then you will proceed to prepare the warrant and place it before the sheriff.
That is correct.
And if not, then you won't.
Yes.
If we could scroll down a little, please. Just at the top of the page there, you say that for search warrants which require to be sworn on oath or affirmed, that would
Yes.
include a drugs warrant,
Yes.
the deponing officer will have to address the sheriff directly about the veracity of the intelligence.
Done.
I wanted to ask you a little bit about that. Am I right to understand that a warrant for drugs would be a warrant made under the Misuse of Drugs Act?
That is correct.
And as you allude to here in your written answer, in that situation, as well as making an approach to you as the fiscal, and on the assumption that you have authorised the placing of a warrant application before the sheriff,
Yes.
the police would still require to persuade the sheriff
Yes.
themselves as to the quality of the information.
The information that the police provide me in a written application would contain the intelligence that the police would have to present to the sheriff and swear on oath that that is true, as far as they're concerned.
And you refer to that being necessary for warrants for drugs or for firearms.
Yes.
If the police were seeking a warrant for, let's say, stolen property or a murder weapon,
Yes.
Would the police require to swear an oath or be affirmed in the same way, or would
No.
you simply convey
No.
that information to the sheriff?
Those are common law warrants which are made by the Procurator Fiscal directly to the sheriff, and the discussions regarding the information and intelligence about the subject matter is between the sheriff and the Procurator Fiscal, not the police. Occasionally, if the sheriff wants to ask the police a question directly, they may do so, but the warrant is from the Procurator Fiscal to the sheriff. It's a common law warrant, and it does not require to be deponed or affirmed by a police officer.
Returning then to the situation with a drugs warrant, where a police officer does require to address the sheriff directly. You've explained that the information that would be laid before the sheriff is the same as the information that the police would have made available to you.
Yes.
And earlier in your evidence, you said that you would draft the warrant. There would be a
Yes.
little bit of backwards and forwards, making sure that the address was correct and,
Yes.
and so on. What part does the sheriff then play when receiving the warrant application and hearing from the officers as to the quality of the intelligence they have and their request for the warrant?
That process has now changed. The previous process was that during office hours, you would accompany the police officer into chambers where the sheriff would put the officer on oath, and the officer would then essentially give the same information given to the Procurator Fiscal. Since the creation of the electronic warrants, that is now all done remotely. The application would come into the Procurator Fiscal. I would then send that during office hours to the Sheriff Clerk, who then passes it to the Sheriff. The Sheriff then contacts the police officer directly, and then the next thing you would know that either the warrant's been granted and has come through, or it's been refused. So you don't have any further part to play in that. Prior to the electronic warrants, you drafted the warrants at home. It was then printed out at home on the office printer, which you got as part of your on-call kit. The police came to your house to collect the warrant, and then went to the sheriff's house to present the warrant, be put on oath, and then they would have the signed warrant.
What was the situation in 2015? How were things done then?
It was, I think, physical hard copy warrants, where you would then prepare the warrant, print it out, sign it. Police would come and pick up the hard copy, and then take it to the on-call sheriff.
And in either situation, what test would the sheriff apply in deciding whether to grant or refuse the warrant?
I mean, essentially for matter for the sheriff as to whether the sheriff accepted that there was sufficient intelligence or sufficient evidence there to reasonably suspect that there was drugs or a weapon or whatever it was that you were looking for within that property.
So it's essentially the same test as the one that you would apply
Yes.
when exercising your gatekeeping function.
Yeah.
Before we move on, at the very bottom of the blue text on the screen, you say if the drugs are suspected to be in a private property, Unless there is an element of urgency, the police will require a search warrant to enter the premises and carry out a search.
Yeah.
We've already spoken about the possibility of a householder consenting to a
Yes.
search. We've discussed warrants, and you've introduced here the concept of urgency and
Yes.
the possibility of search without warrant
Yes.
if the situation is urgent.
Yeah.
Can you tell us a little more about that?
It depends upon the circumstances. If the police believe that there is a risk of evidence being destroyed or drugs being flushed down the toilet, then they can. It would have to be justified at a later stage. They can enter the property to prevent the destruction of any evidence or the disposal of drugs, but it would have to be extreme circumstances. The only way I could give you an explanation, if the police have intelligence, say a car is on its way to deliver drugs, somehow the driver of the car suspects that they're being followed, they stop, go straight into a house which is not known to the police, and the police believe that the drugs are about to be destroyed, then I think they would be justified for them to go into that house and try and recover what they can.
In a situation where the police don't have a search warrant or other lawful ground to carry out a search, such as the householder's consent or urgency of the type that you have described, what would be the consequences if they were to search a property regardless and seize evidence?
The likelihood is that the search and recovery of the evidence would be deemed inadmissible and in later court proceedings.
I'd like to ask you a few questions about record keeping when you're on call. Do you keep records of the calls that you receive on call, any advice you give, any decision that you might make?
Yes.
How are they recorded?
They are, these days it's recorded on my laptop. In the past, used to be recorded on pieces of paper or a notebook.
And what was the position in 2015?
It would be recorded in a notebook.
Can I take you please to paragraph 8 of the statement? And the second paragraph in blue text. You say, insofar as on-call warrants are concerned, if a written application is received from the police, this and any search warrant applied for is retained in electronic or paper form, the latter much less so now in the age of electronic warrants, in line with the Crown Office data retention policy.
Yes.
And if we can scroll down, please. If we can stop there, please, and look at the final substantive paragraph. You say, in cases where the application is refused during the initial telephone call, for example, in a case such as this, there is no copy of an application unless the police have pre-prepared one and retained it themselves, or a warrant, as there is no need to
Yes.
prepare a warrant. The only record I would have had was the handwritten note I took during the telephone call, which I would have taken to the office and put in a folder holding my on-call notes and subsequently destroyed securely. I also have secondary notes from when I prepared my on-call claim form at the end of the on-call week and submitted electronically and retained an electronic folder on my COPFS laptop.
Yeah.
Can you explain how information makes its way into your on-call claim form?
Whatever calls I received during the week, or certainly in 2015, would have been in a notebook. If the matter proceeds to a warrant application being, say, approved by me, and they're on to the sheriff, the police are required to submit a written application. So that will come in a typewritten form on a standard police search warrant application form, which you would then keep, and you would then also have a copy of the warrant. So you would have a full record of the not only the conversation but the information which was given to you by the police at the time. If the warrant is refused, or the application is refused by me, there is no written application submitted by the police, either because they haven't already done so, or because they know even putting that forward would be essentially futile, because the application has been refused. So no, I would not then have a copy of the whatever information that the police were planning on submitting in the event of my saying yes, there is enough information there for me to apply for a warrant to the sheriff.
So in that situation, you would have your handwritten notes that you
Yes.
took at the time of the call.
Yes.
And back in 2015, they would have been handwritten notes
Yes.
rather than computerised
Yes.
records.
And then I would have taken them to the office and put them in the on-call folder, and then at the end of the week submit my on-call claim form.
When you submit the on-call claim form, is that in respect of the additional time that you've worked out of hours, and you make a claim in respect
Yes.
of that time, a financial claim? And should we understand then that when you make that claim, you have to explain that you spent 5 minutes doing this or half an hour doing
Yes.
that to justify the
Yes.
financial claim that you're making? So there would be a record, what you call a secondary note, saved within your actual claim form.
Yes.
And I believe you explain in your statement that the handwritten notes that you would have prepared back in 2015
Yes.
will have been long since destroyed.
Yes.
And so the only record that is now available in relation to on-call work that you did in 2015 will be your claim form.
That's correct.
Mr. Kapadia, I'd like to move on to ask you some questions about a call that you received on the 4th of May of 2015 when you were the on-call depute. I know that you say in your statement that you don't recall which officer it was who phoned you, but we'll hear evidence from a DC Robert Finch that he phoned you,
Yes.
and I don't think that you...
I can't dispute that if I recognise the name from my time working in Fife, and he was a detective constable in Fife Constabulary.
If we can turn to paragraph 9, please. At the bottom of the screen, you explain the only notes that you have in relation to this call come from the on-call claim form,
Yes.
as we've discussed. And you say this was a call from the police on the 4th of May 2015 at 16:46 hours, lasting approximately 5 minutes, which notes TC, would that be telephone call?
Yeah.
Drugs search warrant, search of property connected to death of Baio.
Yes.
Is that the only record that you now retain in relation to the telephone call that you received on the 4th of May 2015?
It is.
Do you actually remember this call, or do you require to rely on the note within your submission form?
I don't recall that, the telephone call, no.
Can you assist us whether you had had any earlier calls in relation to the death of Mr. Baio? He had passed away the previous day.
I had not received any calls the previous day, no. I think the only 2 calls which are listed, one was from Force Control, which would have been the introductory call, and a few minutes after that, the call from the police officer.
So was this your first involvement in any way in the police investigation following the death of Mr. Baio?
Yes.
And was it indeed your only involvement?
As far as I recall, yes.
You say, this was my only involvement in the matter where it would appear that I was called by the police with a request to apply to a sheriff for a search warrant under the Misuse of Drugs Act 1971 for a property which was connected to the death of Sheikh Baio. From recollection, it was for a minute amount of cannabis and a grinder, and it seemed to me at the time that the link to the death was somewhat tenuous, in that the information I had was that the property to be searched was connected, in inverted commas, to the death. I did not have any details about the death, or how it had come about, or any indication that the death had resulted from the drugs from that property. Can we scroll down a little, please? Okay. Before I ask you any questions, can we look briefly at what you say in paragraph 18 of your statement? You say your understanding was that the police had advised you briefly of the death of an individual and wanted a warrant for a property for a small amount of cannabis and possibly a grinder, and the property appeared to be connected to the death. I refused the police application because, from recollection, it did not appear that the death resulted from the drugs or that there was any previous intelligence of drug dealing at the property. It did not appear to me that a search warrant was proportionate under those circumstances. I want to ask you a few questions to help us all to understand why you refused the application. Firstly, can we be clear about what the application related to? You refer to cannabis, a minute or small amount of cannabis. Do you know what quantity of cannabis?
No, but it would not have been significant. For example, saying that there are dealer quantities of drugs in that property, because otherwise I would have then asked further questions about what intelligence that the police had in relation to drug dealing from that property.
So this small or minute amount, should we understand that it would be what might be thought of as a personal
Yes.
amount, not a
dealer level.
Not
yeah.
a dealer level. All right. And if we were to hear evidence that the police assessed it to be half a gram or a gram, would that fit with your understanding of what a small or
Yes.
minute amount is?
Yes.
There's reference there to a grinder. What's a
Yes.
grinder?
It's, I think, what people use to grind cannabis to consume it. I've only ever seen them in productions in plastic bags, so that is what I would assume that it's meant by grinder.
Okay, I'm maybe asking the wrong person.
You're
that
certainly
question.
asking the wrong person.
Let's move on to safer ground. Can you help us to understand why you thought the link between the property and the death was tenuous?
From my recollection and practice, if they were saying that Mr. Baio had obtained drugs or consumed drugs in that property, but it had no bearing on the death. So that is what I meant by a tenuous connection between the property to be searched and the death. The example I gave you earlier on, that if somebody had obtained drugs from a property and as a result of which had died, then there would be a direct connection between the property to be searched, so that the police would have grounds to go and recover any drugs for evidential purposes and also for the health and safety of the general public, so that the drugs were not further distributed to anybody else.
You say that it didn't appear that the death had resulted from the drugs. By that, do you mean the cannabis
Yes.
found within this property? There's mention in your statement to you not being aware of any previous intelligence of drug dealing at that property. How did you know that? Did that information come from the police? Is that the sort of inquiry they would make before calling you?
No, that's based on the fact that I refused the warrant. If the police say that there was a history of drug dealing from that property, or a known drug dealer lived at that property, that would all be intelligence that the police would give you in support of the application to get a search warrant to search that property, to say that numerous individuals attended that property at various hours of the day to buy drugs, and that would help build a bigger picture in terms of whether or not the police had reasonable cause to suspect that there was drugs inside that property.
And that intelligence was absent in this case?
Yes.
You said that it didn't appear that a search warrant was proportionate in all the
Yes.
circumstances. Can you help us to understand what you mean by that, not proportionate?
I meant by simply the amount of drugs that the police said that they were either had or were looking for, because if the police requested a search warrant every time they stopped a person who had a half a gram or a couple of grams of cannabis, then the system would break down and it would not be proportionate in terms of the eventual outcome as to whether or not the police would be granted powers in terms of a search warrant to force entry to a property to go and find a small cigarette or crumbs of cannabis.
Thank you. Can we look at paragraph 35, please? Where you explain a little more about your reasoning. The officer I spoke to was looking for a drug search warrant for property, as I have noted, connected to the death of the deceased, where I took the view the connection was tenuous. I was being formally asked to apply for a search warrant, which was normal, except the amount of drugs to be recovered was very small. If I can pause there, you said at the very beginning of your evidence that ordinarily, when the police apply for a search warrant for drugs, it's for more substantial quantities,
Yes.
or it's for what you called dirty drugs.
Yes.
How common is it in your experience, whether in the office or on call, for an officer to make an application for a warrant for a minute or small quantity of cannabis?
I would say it was quite rare.
I was being formally asked to apply for a search warrant, which was normal, except the amount of drugs to be recovered was very small. Normal practice would be to ask what intelligence the police had about the individuals and their connections to drugs or to the onward supply of drugs. If prima facie there was enough information available to me to apply for the search warrant, the police officer would be requested to submit a written application which would contain full details of the property to be searched, the occupants of the property, what intelligence the police had about the individuals or the property, e.g. the property was a known safe house to store drugs, or that the occupier was a known dealer, and there were recent reports of individuals regularly attending to buy drugs. And is that precisely the sort of intelligence information that was missing from the picture here?
Yes.
You continue. If the written application and information reflected what I had been told over the phone and it was necessary to do so, then I would take steps to draft a warrant and submit it to the on-call sheriff at any time of the day or night. An example of the necessary urgency would be if the police had received a tip-off that drugs were about to be moved from a property, or a dealer had been arrested in possession of drugs and his or her associates might go to the house concerned and remove the drugs or paraphernalia for the dealer or indeed
Yes.
for themselves. So here are you giving an illustration, having explained the reasons for refusing this particular warrant, you're giving an example of the type of case where you would not only be willing to put a warrant before the sheriff, but you would be willing to do so in the middle of the night.
Yes. I mean, I've occasionally got calls where a car has been stopped on its way to deliver drugs, and if the courier does not go to where he's supposed to be, or he or she is supposed to be delivering the drugs, then suspicions might be raised. And if there are other drugs at the property where the courier has come from, then the opportunity to search that property might be lost, because the person might be in custody, somebody might get suspicious and go straight to the house to remove drugs, cash, or any other paraphernalia that might be incriminatory.
You explained earlier in your evidence that in a situation possibly of that sort, urgency in and of itself could potentially justify a search without warrant, but it's always better to be safe than
Yes.
sorry, and if time permits,
Yes.
then a warrant should be sought.
Yes.
Can we go to paragraph 29, please? There are, in fact, 2 paragraphs with 29, so if we could go up a little bit, please. There we are. You were provided, Mr. Kapadia, with an extract from DC Finch's statement.
Yes.
And asked to comment. So DC Finch in his inquiry statement says, I've written in my day book relating to investigation, ? Putting pen through it, no wanting to bother Sheriff 1700, spoke to ANPF, operational matter from prosecution point of view, nothing will be done. I've been referred to my notebook, pages 2 and 3, Monday 4th of May 2015, 1700, spoke to PF Dev Kapadia, not authorised to approach JP or Sheriff Warrant. Prosecution would do nothing. Operational matter. And if we scroll down a little further, you were invited to comment on these entries, and you say, I don't recall using these words, but accept that was the tenor of my response, i.e. that the connection between the property was tenuous, as described to me, and that any offence regarding the cannabis in the grinder was de minimis and would not reach the threshold of prosecution in court for any offences relating to the drugs themselves. The on-call facility is not designed to be available for small amounts of drugs, which at best would be marked for non-court disposals, such as fiscal fines or warning letters. On that basis, I would not bother a sheriff for a de minimis matter. I want to ask you a few questions around what is said in DC Finch's inquiry statement and his day book and your response, just to help us all understand your decision-making here. You refer to any offence around the drugs as being de minimis, just for the benefit of any members of the public who might be listening to your evidence. What do you mean by an offence that's de minimis?
That technically it is an offence, but the quantities involved are so small that they would not be marked for court prosecution.
And is that what you mean when you say would not reach the thresholds for prosecution?
Yes.
You say too that the on-call facility is not designed to be available for small amounts of drugs, which would at best be marked for non-court disposals.
Yes.
Why is a call of this sort perhaps not what the on-call facility is designed for?
Because from my understanding that it was a small amount of drugs and associated grinder, which in itself is not unlawful to have, but the grinder itself might contain traces of cannabis, and so what was being presented to me was, yes, technically an offence, and depending upon the circumstances, it might be looked upon at the lower end of the scale in terms of how somebody marking a case with the report of, say, a gram of cannabis might result in a warning letter or a fiscal fine. So something of that nature. It certainly would not reach the threshold of being prosecuted at the lower ends in the Justice of the Peace Court, for example.
So even at the lowest end of the criminal justice system, this case was unlikely to ever make its way into court?
No.
You say on that basis I would not bother a sheriff for
Yes.
a de minimis matter. How would you have anticipated a sheriff would have reacted if they'd been bothered out of hours for something like this?
It would have depended upon which sheriff was on call that week, but the responses would have ranged from fairly expletive, depending on who the sheriff was, to a polite no.
And Mr. Kapadia, did you yourself feel bothered by the police calling you about a matter of this sort out of office hours?
Yes, to a certain extent. I would not have expected to be called for that. I've had other calls in respect of, say, small amounts of stolen property or a minor assault where the police think that they might want a search warrant to go and get stuff. But it would depend upon the circumstances. But yes, I've had very few calls where the drugs are minor and there's no other evidence of dealing. That's not to say that somebody who's been caught with a small amount of drugs is not a drug dealer. Even the presence of no drugs sometimes might invite a warrant, for example, if they're simply carrying a large amount of cash, or if they've been stopped and a phone has been found, or a tick list has been found, and might give you further information about larger amounts of drugs. But in this case, no, there was just a small amount of drugs and nothing else.
What would you have expected the police might have done here as an alternative to picking up the phone to you out of hours?
Just seizing the drugs and perhaps submitting a report, standard prosecution report.
If the police had seized the drugs, and we might want to hear that in fact they did seize the drugs without a warrant, either because they haven't sought one or because it has been refused or not put before a sheriff, what would be the basis of their authority to seize the drugs?
Well, the actual seizing of the drugs would be that it is unlawful to be in possession, and I would not expect the police to be leaving behind any drugs that they find, regardless of the amount. If they've stopped somebody under the Misuse of Drugs Act and found, let's say, half a gram or a crumb of cannabis, I wouldn't expect them to be giving it back to that person to say, on your way. I would be expecting them to seize it, so that that person no longer had possession of something that they were not entitled to be in possession of.
Can we look at paragraph 30, please? You were asked whether you recalled saying words to the effect of putting a pen through it.
Yes.
We saw that in DC Finch's inquiry statement when we looked at paragraph 29. And you said, and you were also asked, what does that mean? Why was it the case in this matter? And you said in your written response, it meant that if the police reported someone for being in possession of a small amount of cannabis, depending on the amount, the accused's previous convictions and the circumstances, there would likely be no further action. Although I no longer have any notes, I would have said that if it appeared to me from the information provided that the quantity of drugs was so small that it would not merit prosecution, any further action would be disproportionate. When you spoke with DC Finch, do you recall whether you explained your reasoning to him, or would appreciate your memory of the events of 2015 is perhaps poor? Would it be your practice to explain your reasoning?
Oh, I would certainly explain my practice, or explain my reasoning as to why it's saying that. I perhaps would have not quite used legalese terms, but I would have told them it was rubbish, and the matter would not be taken. It would be taken any further.
We can look at paragraph 33. Again, in both the DC Finch's inquiry statement and in his notebook, he has used the words operational matter in a context that suggests that that's something that you might have said to him. And you were asked whether you recalled saying that the matter was an operational one, and what did that mean? You said again, I don't specifically recall saying this, but it's something I would say because I don't have the power or authority to prevent or advise the police what to do in terms of reporting an offence through a standard prosecution report. But I can tell them what the likely outcome would be in terms of marking a case, and therefore reporting a de minimis matter such as a few crumbs of cannabis or the tail end of a joint would be a decision for the police and an operational matter. Can I ask you, Mr. Kapadia, at any point is it up to the police to decide whether someone is prosecuted or not?
No, it's not up to the police to decide because the prosecution decision rests upon the Procurator Fiscal once the police report has been received, and that effectively starts the ball rolling in terms of criminal procedure from a crime being detected. It doesn't mean that every crime that's detected is always reported to the police. The police sometimes have discretion as to whether they take matters forward or not. So the example I've given, that if you've got 16 or a 17-year-old being searched under the Misuse of Drugs Act and a tiny crumb of cannabis had been found in the pocket, that would be an operational matter for the police as to how they deal with the matter, whether they arrest that person, whether they report that crime, or whether they simply deal with it by way of a police warning or whatever other means that they have at their disposal to deal with such matters. I can't stop the police from reporting the matter if they were insistent on doing so. The past that they have, and I then have to take a decision in terms of whether or not a prosecution or any other form of fiscal action is merited.
So the decision making isn't for the police, it's for the Fiscal. The most the police can do is submit a report to the Fiscal, but they cannot influence the decision that the Fiscal will make.
No, they cannot do that. On the other hand, I could give them subtle hints that there's no point in wasting their time and resources in going through drafting up an SPR and submitting it, because the eventual outcome would be, just as I was telling you, would be a waste of everybody's time.
Mm-hmm. And was your statement to DC Finch that this was rubbish an example of that sort of hint?
Yes.
Okay. Would it be a good use of time for the police to report something like this to the Fiscal?
At that time, from the information that I had, no.
Would it in fact be a waste of time?
Yes.
In these circumstances, would you have expected the police to go on and charge the householders, caution and charge the householders with possession of a controlled drug?
That would be entirely a matter for the police. It's an operational matter. I would not have interfered with that.
Okay. So this is exactly the sort of area that you wouldn't trespass on. If they had been cautioned and charged, would you have expected a report to be submitted on the back of that?
Not everyone who's cautioned and charged is a subject of a police report. The police might, having done all that, not submitted a report. But generally speaking, yeah, once somebody's charged with an offence, then yes, I think the police would then submit a report.
To your knowledge, was a report ever submitted in this case?
I have no idea.
Can we go to paragraph 38, please? So you had refused the warrant, or
Yes.
refused to put an application for a warrant before the sheriff, I should say, and you were asked, did you expect the herbal matter to be seized? And you replied, if the police had found the herbal matter, I would expect them to seize it, regardless of the amount, as it's a controlled substance under the Misuse of Drugs Act 1971. I would also expect the police to be dealing with very small quantities by way of a police warning, rather than wasting resources for very minor matters. And you explained earlier in your evidence that in a situation of this sort, even if there were no warrant, no urgency and no consent, you would still expect the police to seize the drugs, because giving them back would be illegal, essentially.
Absolutely.
In paragraph 39, you asked whether you expected the herbal matter to be tested. And you replied, I would expect the police to presumptively test the herbal matter, but as I have said, the reporting of the same is an operational matter for the police. And again, you reiterate the point that for minor amounts, it would be pointless to send a report or to report it through a standard prosecution report, because in practice, very small amounts are unlikely to be prosecuted. And at best, an accused might be given a warning letter or a fiscal fine at the very bottom end of the range of prosecutorial disposals available. Yes. And if we can look at paragraph 40, please. Again, you anticipated the police seizing the cannabis and the grinder, and that they wouldn't be left in situ. This may be an operational matter for the police, so please tell me if it's not something that you're able to help us with, but do the police have the discretion in cases like this to issue a warning?
I believe so. I'm not entirely familiar with the what guidance the police have in terms of their own internal processes, but it is entirely a matter for the police and how they deal with these matters, and would not expect them to expect an input from the Procurator Fiscal as to what to do with it.
So in the same way that they cannot influence your decision-making around, say, whether to prosecute a case or not, it wouldn't be within your gift to tell the police, this is rubbish, what you should be doing here is issuing a warning.
Yeah, I can't tell them what to do. I could suggest that that's an option that they might take, and it's entirely a matter for them whether they take that advice or not. And it wouldn't bother me either way what they decided to do, because, as I say, that I would be trespassing on their function.
After you concluded your call with DC Finch, having told him that the application was not going to be put before a sheriff, did you ever hear anything more about this?
No, I don't believe so. And certainly, if I'd got any calls, I mean, this was, as looking back, an ongoing matter, and it would have gone into, let's say, the next day. During the course of the day, they would have contacted somebody else about what they were doing and why they were doing it. So, from an on-call point of view, no.
Thank you. Can you bear with me just a moment? Sure. Other questions? Thank you.
Okay.
Are there any Rule 9 applications? No. Well, thank you very much, Mr. Kapadia, for coming to give evidence to the inquiry. I'm going to adjourn now, and you'll then be free to go.
Thank you.
We'll take a 20-minute break at this point. Good morning, Mr. Finch. Would you say the words of the affirmation after me, please? I solemnly, sincerely and truly
I solemnly, sincerely and truly
declare and affirm
declare and affirm
that I will tell the truth,
that I will tell the truth,
the whole truth,
the whole truth,
and nothing but the truth.
nothing but the truth.
Ms. Thompson.
Good morning, Detective Constable. What is your full name, please?
Robert Finch,
How old are you?
41,
How many years police service do you have?
15.
There should be just to your left a blue folder. Would you mind opening that up and having a look inside? You should find inside that folder the operational statement that you prepared on the 11th of May of 2015. That's PERC reference 00143. Do you have that?
Yes, I do, yeah.
And we'll come to your inquiry statement shortly, but within your inquiry statement you do say that that original statement is accurate at that time to the best of your knowledge, and your original statement is the best and most accurate piece of information you can provide the inquiry. Would that be fair?
Yes.
You should also have within the folder a copy of your police notebook from the 4th of May 2015, which is PS 03199. Is that there?
Yes.
And your daybook, which is PS 18485.
Sorry, that's not my writing. That's somebody else's daybook.
Oh. Okay. Well, I wasn't intending to take you to it, so we'll see how we get on, and
Okay.
if we need to try and hunt it down, then we will. In any event, we've got your notebook, and there should also be your inquiry statement, which is the inquiry reference 189.
Yes.
Now, if it would help you to refer to any of these documents at any point, then you're welcome to do that. I'll be putting paragraphs up on the screen. If there's anything you would like me to bring up, then just say so, and we'll do that. If we can begin by looking at your inquiry statement, and it's going to come up on the screen now, so you don't have to go to the folder if you don't want to. Can we go to the very last page of the statement? It's 27 pages long. And we see that it was signed by you on the 15th of November 2022. Your signature has been redacted, but your signature should be on the hard copy.
Yes, it was,
within
yeah.
your folder. You saw
I've
that.
noticed that, yeah.
If we can look at the final paragraph, paragraph 145, you say that you believe the facts stated in the statement are true, and you confirm your understanding that the statement may form part of the evidence before the inquiry and published on our website. When you gave that statement, did you tell the truth and do your best to give a complete and accurate account of events?
Yes, I did.
Can we return to the beginning of your statement, please, just to put your evidence in context? At paragraph 3, you explain that you joined the police in 2007, you were a police constable until 2013, and you joined the MIT, which we've heard is the major incident team, is that right?
The major investigation
beg your
team.
pardon, major investigations team in November 2013. When you joined the MIT, is it called the MIT for short? Is that
Yeah,
right?
I would call it the MET
MET.
as an abbreviation.
When you joined the MIT, was that as a detective constable?
Yes, I think until you do the course, you're technically an acting detective constable.
I see. You've been with the MIT since November 2013, and you were a detective constable with the MIT in May of 2015.
Yes.
You were also at that time a crime scene manager, and if we can look briefly at paragraph 11, you explain that you completed a 5-day CSM as that crime scene manager
Yes.
course at Tullyallen, and that was in February 2015. So you were a detective constable and you had received training in crime scene management in February of 2015, so relatively recently before the events of May 2015. I'd like to move on to ask you questions now about the 4th of May of 2015. And that was your first involvement in the investigation following the death of Mr. Baio, and you explain elsewhere in your statement that you were on a rest day on the 3rd of
Yes.
May and returned to duty on the 4th of May. and you were deployed on that day as a crime scene manager, and this was in fact only your second ever deployment as crime scene manager. Tell us a little about what your role as a crime scene manager involved.
So I would be briefed and deployed by a senior investigating officer. My responsibility would be to direct and coordinate crime scene staff in order to examine and search and record scenes, whether it's scenes of serious crime or serious incident, not necessarily crime. And I would be responsible to the staff at that scene to ensure the health and safety and well-being so that they can function to the best of their ability.
If we can go to paragraph 23, please. You were shown your daybook, I think, when you gave this statement. And although the daybook that is in the folder today appears to be the wrong one, can you confirm that when you gave this statement to a solicitor from the inquiry team, you had sight of your own daybook, and it was the right one?
Yes.
So when we see extracts from your daybook in here, in the body of your statement, you have seen the daybook and satisfied yourself that it was your daybook and in your writing.
Just for absolute clarity, I think from... For absolute clarity, I think at the time that I gave the inquiry statement, I had the daybook in front of me. Mr. Bruce hadn't been provided a copy at that point, but I referred to it throughout, given that statement, and very soon after that, I provided a copy to the inquiry team. So I don't think it's quite accurate that Mr. Bruce showed it me. I think I was referring to it whilst I was providing that statement.
In any event, when you gave the statement, you had a copy of your daybook in front of you. We seem to have the wrong one in the folder today. I gather the right one is now being printed, and if we need to take you to it, we will.
Okay.
But by way of convenient shorthand, I think the passages from the daybook that you were looking at when you gave the statement have been copied over into your statement, and it was the correct daybook that you were looking at that time. All right. So returning to paragraph 23, my daybook states that I've been told I'd be getting deployed. I'd scribbled some ideas of what would be needed to kick off. I refer to page 3 of my daybook, 8:30, instructed by DCI Hardy, will require to assist as CSM for death in Kirkcaldy yesterday. So this details your first involvement in the investigation following Mr. Baio's death, and that was at 8:30 on the morning of the 4th of May.
Yes.
Can we look briefly at paragraph 25, please, just in terms of who else was involved by this point in time and the hierarchy? You explain DSU. What does DSU stand for, please?
Detective Superintendent.
Should that be DS? Okay, DSU, Detective Superintendent, thank you. Pat Campbell was in charge of the inquiry at that time. I was also briefed by DCI, that's Detective Chief Inspector Keith Hardy. I don't recall any direct briefing from DSU Campbell. DI Stuart Wilson became involved, and he was more involved in daily tasking and briefing. I don't know what Stuart's role was, maybe Deputy Senior Investigating Officer. At paragraph 26, again, you've referred to your daybook and stated 100, I think that would be the time, 100 hours. Briefing, Operation Burney, DSUP Campbell, PERC-led inquiry. So you've attended a briefing at 10 o'clock in the morning of the 4th. What would be the purpose of a briefing?
To explain the known circumstances at that time, and to allocate actions to individual officers for that day.
If we can look at paragraph 29, please. This is another extract from your daybook, and you confirm at paragraph 30 that the information in fact came from the briefing and from DCI Keith Hardy. Function back to Dick's watched boxing, deceased became paranoid, end up at Saeed's home address, purple-white pills out of sock, flushed by Saeed, had a fight and stormed off, 0500 approx. Deceased went home 0700, blackmail carrying knife, cops attend, restrained Pava CS, no effect, bat and strike, possibly to head. HC, would that be handcuffs?
Yes.
HC to rear, leg restraints, went still, CPR, ambulance. Hospitals. This is the information that you were provided with at the briefing. We see there blackmail, carrying knife, cops attend. What was your understanding as to whether Mr. Baio had a knife or not at the point in time that the police arrived?
I don't think it was clarified further than that. That was, I think the sentence there, blackmail, carrying knife, that's a reference to what was reported by members of the public. That's how the call was came into police.
We've heard, in fact, that Mr. Baio may have been handcuffed to the front. You've recorded it here, handcuffs to the rear. Does anything turn on that? Is that of any significance?
I don't have any recollection to clarify that, I'm afraid.
If we can move on to paragraph 31. There's a locus at Hayfield Road where he, that's Mr. Baio, had been restrained. I was told the deceased's address at Crescent, and then there's a reference to Martin Dick's address, a friend of the deceased, and officers themselves had equipment that had been seized. So is this a discussion around the different loci that the police were looking
that was
to?
still forming part of the briefing.
Okay.
Yeah.
Okay. And at paragraph 32, you refer to your daybook again, and there's an entry that someone has now returned to the Said's home address. Can you explain that to me, please? Said H-A?
Yes, H-OK stands for home address. Right. Said is a poor spelling of the witness, Said. It was explained that address was no longer under police control. It had been examined and returned to the occupier, which I believe was Mr. Said.
I see. And at paragraph 34, you were told, I think this is still in the context of the briefing,
Yeah.
that priorities were the post-mortem and to progress the loci that had been secured. There's a separate crime scene management briefing, and you, at that point, were tasked to progress the loci at Martin Dick's home address and Aaron Crescent, which was the deceased's home address. That was your task, or your tasks for the day. What does it mean to progress a locus?
So I think the briefing by DCI Stuart Houston went into more specific about what was expected of us that day, but it was my understanding was to photograph the addresses and to conduct an initial assessment to establish if there's any evidence that's relevant to the investigation.
Tell me about an initial assessment. What does that involve?
So it would involve a thorough walkthrough of an address in a methodical order, a visual examination of what's at that address.
What are you looking for?
At that time, I think there was mention, obviously, of the knife. So we were looking if there was any obvious knife set that was missing, a particular knife. There was mention, I believe, of fights and disturbances. We were looking to see if there was anything that would indicate that has occurred. And in general, just anything that would indicate Mr. Baio's movements and events that evening going and leading into the morning.
Can we look at paragraph 36, please? Where you explain the procedure, I think, after a locus has been seized by the police. So generally, hypothetically, for this one and from experience from other incidents, we would ensure that they had alternative accommodation and contact details, so they being the householders.
Occupiers, yeah.
Occupiers. The moment we could return that locus back to them, they would be contacted. So it's you who would be taking the householders' contact details.
No, not necessarily. No, not necessarily myself. It was a large inquiry team that day, so I would expect and anticipate that somebody has their contact details and will keep them updated throughout the day.
I beg your pardon. That's entirely my fault. I meant you, as in the police.
The police, yeah.
The police who would be taking contact details for the occupiers. They would ensure they had alternative accommodation and that the police held their contact details so they could be notified when they could get entry to their home again. They would most likely be contacted to provide a statement to the inquiry team at some point, but I can't give specifics on this one because my task that day was purely to process the addresses. I don't know if it was from the briefing, but I did have an awareness at the time that Mr. Baio lived with his partner and his infant child. That gave me a huge sense of empathy, so I do recall that.
Yeah.
Now, I appreciate this was a large inquiry. There were a number of police officers at each of the loci, and I don't believe that you yourself were responsible for seizing Martin Dick's address or the address at Crescent. That had been done by colleagues before you arrived at either address. Is that correct?
Yes. Yeah.
But just as a generalisation, as you've offered some information to the inquiry about the procedure where an occupier is asked to vacate when their home address is seized, they provide their contact details so you can let them know when they can come back. I wanted to ask just a couple of questions around that. In particular, I wanted to know what would happen if the occupier needed to get back into their house for something.
Yeah.
Would they, in the ordinary course of things, be allowed to come back into their house for something?
Yeah, we would facilitate that. Or to give you an example, if they wanted to collect clothing or a particular item, and it wasn't deemed relevant to the investigation, we would facilitate that. We'd either supervise entry or collect those belongings on their behalf.
Okay, so if it wasn't relevant to the inquiry, you'd either supervise the return to the property to collect the items, or you would do it on their behalf.
Yes.
You mentioned clothing. What about things like car keys?
It would depend on the investigation. If that vehicle wasn't relevant to the investigation, then yes.
Okay. Pet food?
Absolutely, yeah.
Breast milk?
Yes.
A breast pump?
Mm-hmm.
Medicine?
Yes. But if it wasn't relevant to the investigation.
Okay. You can think of any reasons why people might not be allowed to access these things if they weren't relevant to the investigation?
If there was potential that other evidence could be disturbed or disposed of, which, as I said, we would either collect on their behalf or supervise the collection of those belongings or property.
And if the things that the householder hoped to get from the house weren't relevant to the inquiry and there was no risk of other evidence being disturbed or disposed of, would you anticipate any problem with them being able to get these things back?
No.
Can we look at paragraph 37, please, where you explain your role on the 4th of May? Your role was to liaise with forensic and scenes of crime staff, coordinate them and complete a plan that comes from the forensic strategy meeting. I was a conduit between the forensic examination team and the SIO, that's the senior investigating officer.
Yes.
I was assigned 2 loci eventually. I was asked to do an initial assessment at each of them. I was to task the scenes of crime officer to take general photographs of the locus, do initial assessment to see if there was any evidence relevant to the inquiry. So that was your role on the day. At paragraph 38, in terms of what you were looking for, and I asked you some questions about this a moment ago, you say, I wasn't given specific information about what may be relevant, but from memory it was passed that Mr. Baio had possession of a knife. It was passed that there were potential drugs. There was mention of these purple and white pills that had been flushed down the toilet. My understanding that we were looking for any loci with an obvious knife set with one missing. We were looking for any controlled drugs or substance or legal high. There was also mention of fights between witnesses and the deceased, so we were looking for any evidence of disturbance within these loci. Also looking for generic things like clothing, anything indicative of people's movements, such as receipts or mobile phones. I don't remember any of that being specifically said. These are just things that I would generally be aware of at any crime scene or any locus that we have secured as part of an inquiry. So you've explained why you might be looking for a knife, why you might be looking for drugs. You also mention clothing. Why might clothing be relevant to the inquiry?
CCTV. If any colleagues are capturing or viewing CCTV, we've got clothing as a visual cue of what to look for. Not in this particular case, but clothing, if there has been a fight or a disturbance, that clothing may be ripped or damaged. That would corroborate a struggle that's taken place.
And whose clothing were you looking for or interested in?
It was, in this particular case, it was just no any clothing out that was visible for CCTV. My understanding at that time was the relevant clothing at the time had been seized already, so it was more a focus on a jacket or a coat that might help CCTV movements.
I want to ask you some questions now about your attendance at Martin Dick and Kirsty MacLeod's home address. If we can go to paragraph 51, please. And here you explain that you arrived at their address at 2 o'clock in the afternoon. You met 2 scene examiners, Gordon Young and Judith Harley. You met them in the street. You grouped in the street before entering together. Again, you confirmed Martin Dick's address had earlier been secured prior to you starting duty, so you weren't involved in the decision to seize his house or the actual seizing of his house.
Correct.
His address had earlier been secured prior to me starting duty, and he was the friend of the deceased. The deceased had been in the address at some point in the early hours of the 3rd of May. I remember there was at least one officer on locus protection. I was happy that was sufficient to maintain the integrity of the address. Now, you were aware that the address had already been secured. Were you told on what authority the address had been secured?
Yeah, I was told that it was permission granted by the occupier.
When an occupier grants permission for their home to be seized and subject to this initial assessment and photographing and so on, would you expect that to be recorded in some way so there couldn't be any dispute about it in the future?
Yeah, I can tell you how I would capture such permission.
Yes.
I would build that to within the witness statement to make it clear that we've explained, that they're under no obligation to do so. It's been explained why, the purpose of doing that and what we're looking to achieve, and the fact that if they become uncomfortable at any point, they can withdraw that permission. And I would, like I say, I would capture that within the body of a signed statement from that witness.
Now, if the locus was secured before the witness's statement were taken, if it had been thought appropriate to ask them to go back to the police station, for example, to give their statement, how might you capture that information?
Probably by means of a paragraph within my notebook, and ask the witness to sign that.
Okay. So you'd record in your notebook then that the witness understood that they were under no obligation to allow you to seize and presumably enter.
Yeah, I'm not aware of any set guidelines around that, but that's certainly how I would approach it.
Okay, and why do you think that would be an important thing to do? Why is that your practice?
To withstand future scrutiny, that we've demonstrated a level of fairness and explanation to the witness.
So this would be an audit trail, if you like, or a paper trail that
Yeah.
would confirm that you had ensured that the witness realised they were under no obligation. You would have explained the purpose, what you were hoping to achieve, and that they could withdraw their permission. And you would capture that either in a statement, or if the statement was being taken later, in a paragraph in your notebook, which you say you would have them sign. Okay. When you go to a locus as a crime scene manager and you're aware that colleagues have already seized that locus, and they tell you that they have the householder's permission, do you rely on what you're being told, or would you ask to see what's written in the notebook or what's been embodied within a statement?
So on this occasion, it was a major investigation, and I was directed to that address by a senior investigating officer, so I have to be satisfied that the SIO is content with permission being granted, and that there's a clear record of that. I believe it was recorded on the home system, this inquiry, so there should be a clear record of that. But I'm satisfied if I'm instructed by an SIO that they've given that level of scrutiny and prior to instructing me.
So it wouldn't perhaps be your place to say, well, before
No.
I go through the front door, I'd like to see the notebook, I'd like to see
Yeah,
the
I
statement.
didn't have any contact with those officers, so it was purely on the instruction from the SIO.
I'd like to ask a few questions about scene entry logs. If we can go to paragraph 53, please. You say there was no scene entry log at the scene. A scene entry log is a legal document that logs any activity in that address, any persons going in and out. I don't know why there wasn't a scene entry log. I don't think there was any reason provided to me as to why a scene entry log hadn't been started. I thought of adding retrospective entries. There is a specific section at the start of the scene entry log to record any persons that have entered the locus prior to the scene entry log being started, but I don't recall filling that in. That was simply information that wasn't available to me. So you describe a scene entry log as a legal document that logs any activity at the address, persons going in and out. You don't know why there wasn't a scene entry log when you arrived at Martin Dick's home address. Would you have expected there to have been a scene entry log up and running by the point that you arrived?
Yeah, I think so. I don't know if there was some confusion that, you know, we were investigating a death rather than a crime, so I don't know if there's confusion there. I'm speculating, but I would have expected a scene entry log to be started the previous day and maintained.
Did you do anything about the fact that there wasn't a scene entry log?
Yeah, immediately instructed the officers to start one.
If we can now turn to paragraph 62, please. Or sorry, 59, I beg your pardon. This is an extract now from your notebook. Attended Dick and MacLeod's home address. Instructed officers to commence scene entry log at 2 minutes to 2. Entered full forensic protection, still photos, no sign of disturbance. So here you record your instruction that the scene entry log has to be commenced. The paragraph that we referred to a few moments ago made mention of the possibility of retrospective entries. You considered making retrospective entries but didn't. Can you explain, please, what retrospective entries are and why you didn't make retrospective entries on this occasion?
Yeah, so within a scene entry log there are a number of pages that are coloured yellow, and that is an area in which we can record officers that have been within that, or that we know have been within that locus, or other persons beyond officers that have been within that address prior to the scene log being started. To give you an example, if officers need to rush in for preservation of life to give CPR, they wouldn't have time to start a scene entry log. So that's an area where we can record who's been in, what action they've taken. The white pages then move on once the scene log's up and running. That becomes a log of who enters and why, and also persons responsible for maintaining the address. Because in this instance the log was started the previous day, there was an unknown number of officers that had been assigned locus protection duties, that I didn't have that information available at that time.
When you say the log was started the previous day, do you in fact mean the log hadn't been started the previous day?
Yeah, when the locus protection had commenced the previous day, there'd been any number of officers between then and 2 minutes to 2 when the log was started. I didn't know who those officers were.
So is it simply an impossible task to try to ascertain that information and make the retrospective entries?
Yeah.
If we could go now to paragraph 52, please. Sorry, 62, I beg your pardon. You say, I was briefed to make an initial assessment, and we discussed what that involves a moment or so ago. You say you were briefed to make that initial assessment, so that was an instruction from a more senior officer.
Yes.
The best and detailed account is in my daybook. I've written at page 8, jacket hanging on banister. I think the process of my thinking at the time was for CCTV teams to look out for clothing of the witnesses. Again, you mentioned CCTV and the relevance of clothing earlier in your evidence. At paragraph 63, you record, at page 8 I also wrote, no signs of disturbance and herbal matter in jar in bed drawer. I drew sketches of the locus. I sketched downstairs and upstairs. So the initial assessment you've described as involving a methodical walk around, and you're very much using your eyes. You're looking for things that might be of relevance to the inquiry. So you've recorded here no signs of a disturbance, and also herbal matter in a jar in bed drawer. Who was it that noticed the herbal matter during the initial assessment? Was it yourself or a colleague?
I've got a vague. It's obviously a large passage of time since. My recollection is it was drawn to my attention by Judith Halley, who's one of the scene examiners. One of the tasks was to record the locus by means of still photography, so we would always allow that to be done before I would enter, just so that that's captured prior to any police disturbance within that address. So from memory, I think it was Judith Halley that brought that to my attention.
And can you describe where this herbal matter was noticed, or was seen to be?
Pardon, sorry, I didn't hear the question.
Sorry, can you describe where the herbal matter was seen to be? It's described as a bed drawer. Is that a bedroom drawer, or is it a drawer on the bed itself?
It was within a divan bed,
I
so there
see.
was a pull-out drawer in the base of the bed. By the time I saw it, the drawer was open, and it was clearly sitting on top of that drawer on open display.
And at paragraph 66, again another entry from your notebook, you say 1500-1505 re-entered with Judith Harvey to assess herbal matter in bed drawer, main bedroom, 2 times grinders, trace amounts, plastic jar, trace amounts. At 67, we re-entered to assess the herbal matter. The drawer in the nearest bedroom was open and the jar was obvious. There were 2 grinders. So your recollection today is that it was Judith Harley who had drawn your attention to the substance and the grinders, and you say that by the time that you saw them, they were on open display within a drawer in the divan of the bed in the main bedroom. Now there's evidence before the chair from both householders, both occupiers, Martin Dick and Kirsty MacLeod, that the drawer was closed when they vacated their house, when the police took seizure of the house, and it must have been opened by the police. Is that something that you can comment on?
It's possible. Certainly, my recollection is by the time I got to the bedroom, it was open. We certainly weren't doing an intrusive search. We would have opened drawers, certainly in the kitchen, for the assessment around the knives. But certainly by the time I saw that, the drawer was open.
Okay.
I've got no recollection of opening that drawer.
As you said earlier in your evidence, the locus had in fact been seized the previous day.
Mm-hmm.
Can you say how many officers had been in the house between the point in time that the locus was seized and you commencing the scene log?
No.
No. And no log was being kept, so we don't know who they were.
Correct.
But your evidence is that by the time it was drawn to your attention, the drawer was open.
Correct.
And the substance in the grinders were on display.
Correct.
And you can't assist us with anything that happened before that point in time. You said you wouldn't have been carrying out, I think you used the word intrusive or invasive search. Can you help us to understand the difference between what you call an initial assessment and what the public might think of as a search? Is there a difference?
Depending on the circumstances again, but a structured intrusive search would be one undertaken by or under the supervision of a police search advisor. And would be recorded, and the wording of the document is intrusive search, and that would be every cupboard, every drawer is searched through thoroughly. The initial assessment would have been, as I've already described, a general visual assessment at that address, potentially involving opening drawers, but certainly not a thorough, detailed search of the contents of those drawers.
Would it be fair to say that it's a question of degree?
Yes.
And that both involve you looking for evidence?
I'm sorry, I don't understand that.
That both an initial assessment and a structured search involve you looking for things that are of evidential value to your inquiry?
Yes, yeah.
And both may involve the opening of drawers?
Yes.
Can we move on to paragraph 68, please? So the herbal matter and grinders had been brought to your attention, and you say from memory, I think I rang DS Moore or DI Wilson and was advised to phone the on-call Fiscal to seek a drug search warrant. I can't recall why we needed the search warrant in addition to the consent. If I can ask you a few questions about that, please. You had been told by a senior officer that the occupiers had consented to the seizure of the house. What did you understand to be the scope of the consent that they had given to the police?
At that point, we're carrying out inquiries into the death of Mr. Baio, so that's the scope of the search. So when we've located drugs, that becomes out with that scope. We've identified criminality there.
Okay, but did you understand then that the householders had consented not only to the seizure of their house, but that for it to be searched for evidence relevant to the investigation into Mr. Baio's death?
Yes, that was my understanding.
So we've heard some evidence that there might be a distinction between the seizure of a property and the search of the property.
Yeah.
And it was your understanding that the occupiers had consented to both, insofar as it was relevant to the police investigation into the circumstances of Mr. Baio's death.
I'm basing that on the instruction from the SIO that existed, yeah.
And of course, what you have now encountered is, on the face of it, a controlled drug. And you've explained that's why there was a need to approach a fiscal for a warrant, because the drug that you had found was perhaps not was perhaps not of evidential value in terms of the investigation into the circumstances of Mr. Baio's death. Did
Correct.
I understand that correctly?
Correct.
Okay. So as we see from paragraph 68, you took advice from a more senior colleague and you were advised to phone the on-call fiscal. And you've explained now, although your statement says I can't recall why we needed the search warrant in addition to the consent, if I've understood your evidence correctly, you have explained today that it was because what you had found wasn't directly relevant to the inquiry itself, but it was evidence of criminality of another sort.
Correct, yeah.
What quantity of drugs are we dealing with here?
Very small. I think at one point I made a reference in my daybook on my notebook that it was probably less than a gram.
Is that what the police might think of as a personal quantity rather than a dealer quantity?
Yeah, definitely.
Would you usually call the fiscal for a warrant for such a small quantity?
It would depend on the situation. Not necessarily, no.
We heard evidence this morning from the on-call fiscal whom you called. He said in his experience it was rare to be called by the police, on-call or in the office, for such a small quantity.
Yeah.
Have you called the fiscal before about asking for a warrant for less than a gram of cannabis?
No.
Have you done it since?
No.
So this is the only time in your career that you've called the fiscal to seek a warrant for less than a gram of cannabis?
As far as I recall, yeah.
Have there been other cases in the course of your career where you have come across small quantities of cannabis or other drugs?
I can't recall to that minute amount, no. Perhaps during a drugs death investigation we come across a grinder with trace amounts that would be seized if a person has died within that property, but no.
So will there have been other occasions where you've stumbled across a small amount of drugs in the course of your career?
During death investigations, yeah.
All right. How did you feel about being asked to call the fiscal out of hours with a view to applying for a warrant for such a small quantity of drugs?
It was an instruction by a senior officer. I felt reassured at the time of day. It was not long after the usual daily court business finishing up. So I can see that it was around about 5 o'clock. So I was comforted by that.
It was your understanding that the occupiers had consented to their property being subjected to a search?
Yes.
If that consent had already been given, was any consideration given to asking them whether they would consent to effectively a drug search?
I can't comment on what the SIO's decision making was around that.
In any event, you were acting on an instruction to contact
Yes.
the out-of-hours fiscal. So let me ask you some questions now about how that call went.
Okay.
The fiscal you spoke with was a Mr. Kapadia, and we heard evidence from him this morning. So he's explained to us the processes and the procedures that are in place when the police need to contact the fiscal out of hours already. Let's look at paragraph 69, which is an entry in your daybook. You say, written in my daybook, relating to investigation, ? Putting pen through it, no wanting to bother sheriff, 1700, spoke to PF, operational matter, from prosecution point of view, nothing will be done. Paragraph 70, you say, I rang the PF and I've informed him of the circumstances. He told us we weren't being granted permission to approach the sheriff for a warrant, and it was an operational matter for the police. And again, if we move down just a little bit, you go to your notebook, and similar information is recorded 4th of May 2015, 1700, spoke to PF Dev Kapadia, not authorised to approach JP stroke sheriff for warrant, prosecution would do nothing, operational matter, instructed by DI Wilson to recover substance and caution occupiers. Can you add to that in terms of your recollection of the conversation that you had with Mr. Kapadia?
I don't think I can speculate that there'd have been a discussion around about what's the connection and relevance to the, if any, to the death of Mr. Baio. What quantities would you estimate it to be? Is there other evidence within the address to indicate that we're actually dealing with a supply case, or is it personal? Is there any information or intelligence in the background that would indicate it's anything other than a personal amount of controlled drug?
And in this case, was there any evidence within the address to suggest that it was a supply case rather than personal use?
Not that I had seen, no.
And was there any intelligence in the background to suggest that the householders were supplying drugs, or that their property had been used in some way for the supply of drugs?
No.
If we can return to paragraph 69, these are your notes, of course, but you recall putting pen through it. Was this you saying you were putting a pen through it, or was it Mr. Kapadia saying he'd be putting a pen through it?
That's not a term I would that refers to the fiscal. I don't have the power to put a pen through it, as that terminology mentions there.
And what would you understand that to mean, putting a pen through something?
The bottom sentence there, the prosecution wouldn't progress that. It wouldn't be in the public interest to do anything with that.
Okay, and why would that be?
Just because we're dealing with such small quantities.
You've also recorded no wanting to bother sheriff. Do you recall anything about that part of the discussion?
Yeah, it's not a direct quote, but I think the gist was that he didn't want to disturb a sheriff at that time of day based on the small amounts.
Operational matter, from prosecution point of view, nothing will be done. From prosecution point of view, nothing will be done. That seems quite straightforward.
Mm-hmm.
What did you understand Mr. Kapadia to be telling you when he said words to the effect of, from prosecution point of view, nothing will be done?
Yeah, as I've said, it wouldn't be in the public interest to, for example, if a report was submitted to the PF regarding those circumstances, no further action would be taken.
And you've recorded their operational matter, and again in paragraph 70, Mr. Kapadia told us we weren't being granted permission to approach a sheriff, and it was an operational matter for the police. Mm-hmm. What did you understand by it was an operational matter for the police?
It's exactly that. It's a choice for police to make as to what further action, if any, is taken.
If we can scroll down a little, please. So, you've had the call with the Fiscal. His notes are to the effect that the call lasted for about 5 minutes. Would that accord with your recollection?
Yes.
And he has given evidence that he declined to put your application for a warrant before a sheriff and told you it was an operational matter. We see at the bottom of paragraph 71, instructed by DI Wilson to recover substance and caution occupiers. Should we understand then that after the call with the Fiscal, you took further advice from D.I. Wilson?
Yes.
Did you make D.I. Wilson aware that the Fiscal was not willing to put the application before a sheriff?
Yes, I will have done, yeah.
And D.I. Wilson told you to recover the substance and caution the occupiers?
Yes.
Can you help us to understand the authority on which you went on to recover the substance if you didn't have a warrant and you didn't have consent?
Yeah, SIO instruction, but my understanding, I'm duty bound to prevent and detect crime and and remove that substance from the public for their safety. So ultimately, I was duty bound to take action and seize that.
You were also instructed to caution the occupiers.
Yes.
How did you feel about that instruction?
I don't recall having any feeling.
Would it be normal police practice, can you say, to caution someone for possession of less than a gram of cannabis?
Yeah, absolutely. Yeah. If I mean, the best example I could give you would be a stop and search in the street and recovering maybe a single joint. That person will be cautioned that if the contents of that joint is tested and is found to contain an illegal substance, they may be reported for the consideration of a prosecution.
And do you know in this case whether the householders were in fact reported for consideration of prosecution?
I personally didn't report them. I couldn't. I think my statement goes on to explain later on that the next day I was instructed to hand over all productions and take no further part in the investigation. So that was prior to an opportunity to field test that item. So I know in my experience it looked to be herbal cannabis, but I didn't have an opportunity to do a field test. So as such, I couldn't put a prosecution report in regarding that.
Would it be normal police practice to caution and charge an individual for possession of controlled drugs before a field test or a presumptive test has been carried out to confirm they are in fact drugs?
Not caution and charge. There's a statutory drugs caution, and I think that the exact wording is later in my inquiry statement.
I think it is. Well, let's have a look at that now. It's paragraph 83, I think. Paragraph 83, I've been referred to my notebook. 1842, A ends, which you explain in the next paragraph is above nominals.
Yeah.
So that's Kirsty MacLeod and Martin Dick. A ends read drug caution verbatim. I have reason to believe that the substances found within your home address is a controlled drug under MDA's the Misuse of Drugs Act,
Yes.
1971. Should analysis of the substances prove positive, you will be reported for offences under the Act. I must caution you that you are not obliged to say anything in reply, but anything you do say will be noted and may be used in evidence. Do you understand? Both understand, neither made a reply. And again, you explain the shorthand used in paragraph 84. So that was the caution that was read over. So should we understand that they were cautioned but not cautioned and charged?
Correct, yeah.
And you've explained that the following day you were asked to hand over productions. We may hear evidence that the PERC began to be incrementally more involved in the investigation from about that point onwards, but you certainly didn't follow this up. This concluded your involvement essentially in this
Correct,
matter.
Yeah.
Okay. You've explained in your statement and in your evidence that you were essentially acting on instructions, both in terms of making contact with the Fiscal, also cautioning the householders. Would you ordinarily go to a senior officer for instructions in these circumstances, or would you, in other circumstances, have your discretion?
No. Throughout my time in the major investigation team, whenever I've been involved in an MI, you take no action without explicit instruction from an SIO, whether that's verbally or a typed, printed action from the home's computer system. That there is nothing done. I don't act autonomously in any aspect of an MI.
If you had been able to act autonomously, would you have done anything differently?
No.
We've heard some evidence, albeit limited evidence, from Mr. Kapadia this morning that the police do have the discretion in at least some circumstances to issue a warning to a person as an alternative perhaps to cautioning them or submitting a report to the Fiscal. Mm-hmm. Is that something you've ever done?
In the areas I work at, I'm not that familiar with a recorded police warning, and when I did work in response and in uniform, it wasn't a tool available to police, so I'm not overly familiar with it. I'm aware of that it exists and in circumstances that it can be used.
Are you able to help us, and please say if you can't, with whether it's a tool that might be used where a person has been found to be in possession of a very small quantity of cannabis?
Yeah, I'm not overly familiar with the exact guidelines or whether this circumstance would fit. I want to say yes, but I can't be certain.
All right, thank you. Can I move on to ask you now about your involvement with the other locus, that is Mr. Baio's home address on Arran Crescent? I believe you also had some involvement as crime scene manager on the 4th of May with the Arran Crescent property. What was the nature of your role at Arran Crescent? Was it identical to the role that you performed at Martin Dick's home address? So what then was the legal basis for you entering and assessing and potentially searching Mr. Baio's home address?
Yeah, so I think when I provided my inquiry statement, it was unclear. I think having reviewed my daybook, I'm content that permission was given for that one as well. Or certainly that's the instruction that I received from the SIO, that permission had been granted.
Let's look at paragraph 90 of your statement, please. This is in relation to Mr. Baio's address. I attended at Arran Crescent about 7 in the evening. I'd been asked if I know the legal basis to search this property. No, and this really jumps out to me when I reviewed my statement. I can only answer that with, at the time, it was SIO-led. I'd have had the firm belief that we were acting lawfully and within the powers of either permission from the occupier or SIO policy in conjunction with the Fiscal and the PERC. But I don't have any specific note in my notebook or my daybook, nor memory as to what that was, whether it was a warrant permission from the occupier or otherwise. And you said a moment ago, you've clearly reflected on this. Before I took you to that paragraph, you said that you were satisfied that it was permission or consent from the householder.
Yeah, I don't have any clear recollection, but I know if you refer to my daybook, I think there's a briefing, and on the top right of the page, there's a bullet point that says warrant -- permission granted. I think having reviewed that, because it's right at the start of the briefing, it refers to both locuses.
Thank you. Thank you, and that's in relation to both loci. So this was the daybook that was missing. Still will be missing from the blue folder, but I believe we might now have it. Can we perhaps let DC Finch have a look? And would it be possible to put that on the screen?
Thank you.
Detective Constable, I'm going to ask for your help here to see if you can help us to find that entry. I think you might be able to locate it more quickly than I can.
I don't see that it's paginated, but I think perhaps page 7.
Oh, yes. Top of page 7.
Yeah. So the previous page is the start of the briefing at 10 o'clock in the morning, and then that goes over the page. Warrant, ? Permission given.
Just for completeness, if we might go to the previous page first, near the top of that, in fact at the very top, 1000 hours briefing, PERC-led inquiry, 5 loci, and then there's a discussion about the 5 different loci, including Hayfield Road, Arran Crescent, Martin Dick's home address, amongst others. And then at the top of page 7, warrant ? Permission given. So the issue of lawful authority to enter and search these loci appears to have been discussed at the briefing. Would that be fair?
Yes.
And the possibility of a warrant being required appears to have been raised.
I think that was my personal consideration. Do I need a warrant before I attended these addresses?
And you have written, this is your handwriting,
Yes.
these are your notes, permission given. So you've been provided that information.
Yes.
That has satisfied you that there was no need for a warrant.
Yes.
You said earlier in your evidence that so far as Martin Dick was concerned, you took his having given permission on authority from a more senior officer. You didn't ask to see a note in a notebook or see his statement. Was it the same in relation to Colette Bell's home address
Yes.
at Arran Crescent? So you were
Yes.
provided with that information by a more senior officer and you didn't look behind it?
No.
Can we go to paragraph 93? I just have a few questions in relation to, sorry, we're going back to the inquiry statement, I'm sorry. In fact, we were at paragraph 90, so let's just pick up from there, please. Paragraph 90 is where there's a discussion about the lawful basis, and we've explored that. And if we look for completeness at paragraph 91, you say you're certain that we'd have acted on clear instructions at the time, whether it was for warrant permission or an SIO policy. I wouldn't have done that unless I thought I was acting legally and with absolute fairness.
Yeah.
If there'd been any question in your mind as to whether the householders had provided consent for the work that you were being asked to carry out, what would you have done?
I'd have queried that with the SIO.
If we can now go to paragraph 93, please. It's 7:20 p.m. by the time you've entered Arran Crescent. There's a reference there to seizing a watch, which I think had been found in a garden.
Yeah.
I've taken full forensic precautions, which you explained by reference to your daybook to mean gloves, overshoes, suit and mask. What was the purpose of taking full forensic precautions?
In hindsight, it was being overly precautious. It was, as I've mentioned, it was my second ever seeing. There was no indication of any forensic examinations requiring to be done at that locus. There was no mention of bleeding injuries. I think I was just being overly precautious.
Had you taken those precautions when you went into Martin Dick's home address?
I can't recall without referring to the scene entry log. I think I probably would have done.
And if you had, or assuming that you did, would you have worn the same clothing when you
Yes.
went into Arran Crescent, or would you have changed into a fresh
I'd
set of
have
clothing?
an entirely new set of protective clothing.
Paragraph 94, you explain that you noticed fridge magnets on the floor, and there were fridge magnets on the footpath outside the property. A watch strap was broken, and photographs were taken, and there was recovery by the scene's examiners. At paragraph 95, you say, I don't see that I've put it in my statement, but looking back now, that is indicative of a potential disturbance. Potentially, fridge magnets were pulled off a fridge and a watch strap with one side potentially pulled off. There was a small flat screen television on the floor, possibly indicative of being knocked over. Were there any other signs of a disturbance within Aaron Crescent that you recall?
Not that I recall, no.
Was there anything more of evidential value within the kitchen that you recall?
I recall seizing 3 knives from the kitchen, and I recall, I think it was a red-coloured rucksack on top of either a unit or a fridge freezer with various tablets inside.
And were they all seized?
Yes.
Okay. Where were the knives found?
I don't know if I can refer to my notebook. I think they were potentially one of the drawers in the kitchen.
All right. I'll see if I can help you with that. If we could perhaps go to paragraph 107. There's mention here of the knives. I can't remember what the knife from the incident looks like now. Is that reference to the knife from Hayfield
Yes.
Road? I think I must have seen the knife from the incident. A photograph must have been shown at the briefing because the knives at Colette Bell's address were visually similar to the knife at Hayfield Road. I've not put that in my notebook, but I wrote my statement days after the fact, so it's clear in my memory. That perhaps doesn't assist us with precisely where the knives were recovered from. It may not be important, but
I'm certain it was a kitchen drawer, but in terms of which actual drawer, I can't be certain.
but your recollection is that the knives were within a drawer.
Yes.
And do you recall whether the drawer was open or closed?
I think it was closed. This, of course, will all be photographed by the SOCO.
Don't worry.
Sorry, I don't see anything. Sorry.
No, don't worry. We can move on from that. So on the 4th of May of 2015, you were the crime scene manager both for Martin Dick's address and for Aaron Crescent. One final question. You have given evidence that when you made your way to Martin Dick's address, there wasn't a scene entry log up and running, and that was the first thing you instructed to happen.
Yes.
Was there a scene entry log set up when you arrived at Colette Bell's address?
I think there must have been, because otherwise I'd have taken the same action and made the same comment in my notebook and statement. So I think there must have been, and from memory there was.
All right. So you've explained the tasks that you carried out on the 4th of May of 2015. Did you have any ongoing involvement in this inquiry beyond the 4th of May?
Very briefly on so I think the next day we were instructed that take no further part in the inquiry and to hand over all productions. That there wasn't much in the way of explanation as to why that was. I had a brief involvement on this, I think it must have been the 6th of May. The Wednesday, I was asked to do a visual examination of a vehicle that had been seized.
All right, I don't think I need to ask you any more questions about that today. Before we conclude, can I ask you some questions about training?
Yeah.
We've touched on training already, and you told us about the crime scene manager's course that you did in the February of 2015. Can we go back to paragraph 20 of your statement, please? If I can take you back to your probationer time at Tullyallen, and you explain week 1 attending police college as a new constable probationer, the entire first week was dedicated to diversity. You go on to say, I can't remember anything specifically from it. I don't recall any other training on diversity and equalities. Do you remember anything at all about that training?
I think that's quite badly worded. I think it's the detail of it I don't recall, but I remember the nature of the training in terms of being aware of diversity and how to approach various issues as a police officer. So it's just the exact detail I don't recall.
Okay. Do you recall what the topics were that were covered over that week-long course?
Yeah, from memory it was broken down to race, religion, gender, and such like.
And you say you don't recall any training on diversity and equality since?
No, although since providing that statement, there has been an online training package released.
Tell us about the online training package.
I haven't had the opportunity to complete that yet.
Ah,
I was
okay.
only became aware of it last week, and we had quite a busy week at work last week.
Okay. Now, you told us that you joined the police in 2007. You had a week of diversity. That would have been in 2007 when you were a probationer. We're now in 2023. Has there been no other equalities and diversity training in the intervening years?
Not that I recall.
Do you recall whether your training back in 2007 covered unconscious bias?
I don't recall that it did, no.
You do, however, say in your statement, paragraph 141, if we might go there, please. You say, in my opinion, I don't believe I hold any biased thoughts. I try every day to deal with every person with professionalism and impartiality. I'm conscious of unconscious bias being a factor, but I don't let it affect how I operate. Can you help us to understand how you guard against unconscious bias playing any part in how you deal with members of the public?
Yeah, the very nature of unconscious bias, you're not necessarily conscious of it, but as I've said there, I try every day to treat people with compassion and impartiality and be professional, to treat people the way I would expect myself or my friends or my family to be treated, and that's the approach I take every day.
You say at paragraph 142, I've been asked if, looking back now, did Baio's race play any part in my involvement in the inquiry? For me personally, no, absolutely not. I acted with professionalism and impartiality. I have a huge amount of empathy for Baio's family, given the family dynamic. It was harrowing when I went to Mr. Baio's address and seeing the setup, being able to relate to that and seeing the child who has lost the father. Honestly, I personally acted with fairness and race, didn't play a part. And do you maintain that view today?
Yes.
You go on at paragraph 144, please, to say, I've never seen any examples of discrimination by police in Kirkcaldy in relation to race. I'm not aware of any other police officers having racist views. I've not heard any racist jokes or comments from any police officers. To elaborate, that's something I'd actively challenge and would be disgusted by. I can honestly say I've never encountered that.
Yeah.
And does that remain your position
Yes.
today? Can I ask you, Detective Constable, whether any of your decisions or your actions on the 4th of May of 2015 were influenced to any degree by Martin Dick's connection to Baio?
No.
Or by Colette Bell's connection to Baio?
No.
And were any of your decisions or actions on that day influenced to any degree by the fact that Mr. Baio had died following contact with the police?
I'm led by the SIO, that's the decision maker effectively, but no.
Thank you. Can you give me a moment, please?
Yeah.
Question. You explained that your involvement came to an end on the 5th or 6th of May or thereabout, that you came off the inquiry, you were asked to hand over productions. What was your understanding as to why you'd been taken off the inquiry?
So it wasn't me personally, it was the whole inquiry team that were instructed to take no further part in the inquiry. It was all a bit mysterious at the time, if I'm honest. There was no explanation given. There was no further instruction other than that, so I don't know, it wasn't elaborated upon.
Thank you. Have no further questions.
Thank you.
Are there any Rule 9 applications, Ms. Mitchell? Detective Constable, I wonder if you would withdraw to the witness room while I hear an application. Yes, Ms Mitchell.
Yes, my lord, briefly. The witness understood that he was there lawfully and that they were carrying out a visual inspection, but also...
This is at the Dick's house?
This is at Dick's house, yes, including opening drawers, etc. The questions I would like to put to the witness was, what was his understanding of the purpose of seeking a search warrant? To ask him why he didn't seize the drugs or the herbal matter and the grinder at the time that he saw them, and whether or not he told Dev Kapadia that he was already in the house and had seen said items at the time of requesting a warrant.
So when you say what was his understanding of the purpose of seeking a search warrant, what do you mean by that?
Well, against the background that he says he was already there lawfully and he was already carrying out a visual inspection and it would appear
I see.
A physical search.
Yes, I understand now. You're referring to the decision to contact the Fiscal.
Indeed.
Yes, right.
So I appreciate it wasn't his decision, but I'm wanting to explore what was his understanding of why he was doing that.
Well, it seems to me that each of these items has been the subject of evidence, and I don't think it would assist me further by exploring any of these points further. So I won't allow that examination. So if you just return to your seat for a moment. Give me a moment while I consult with my assessor. It's back with us. Detective Constable, can you help me with one matter? You gave evidence that there had been a briefing that you attended, and in your book you have noted warrant ? And then you were told that the house was seized with consent, and that was the person giving you the briefing that made reference to consent. Is that correct?
Yes.
And who was that person?
It would either have been DCI Keith Hardy or there was a crime scene coordinator allocated who was DCI Houston. I think it was DCI Hardy.
Thank you. Now, thank you very much, Detective Constable, for coming to give evidence to the inquiry. I think that's all the evidence today, is that right, Ms. Coon?
That's correct. We've completed all of
Very
our
well.
evidence.
I'll be adjourning in a moment and you'll then be free to go. So adjourning now until tomorrow morning at 10 o'clock.